Hello everyone, my name is Aarti and you're watching HW News. In a progressive step towards the rights of women in India, the Supreme Court today ruled in favor of safe and legal abortion, not only for married but also for unmarried women. In the course of pronouncing the ruling, the court also made certain observations on marital rape. The three-judge bench of the Supreme Court, led by Justice DY Chandrachud, also included Justice AS Bopanna and Justice JB Pardiwala. The court said that unmarried women cannot be denied safe and legal abortion under the Medical Termination of Pregnancy Act. In that regard, both married and unmarried women have the equal rights. The court further said that the scope of law will also cover abortion in case of a marital rape. But marital rape in this case is only limited to the ambit of this law, that is MTP Act. Now, what is this law and why is this ruling a big step towards female reproductive rights in India, and what will be the far-reaching impact of it? Let us understand in today's video. But before that, if you're watching this video on our YouTube, then do subscribe to our channel right away and press the bell icon to never miss a video update from our side. If you're watching on Facebook, then please follow our page. Now you can also access our articles, videos and live TV with just one click on our app. If you haven't already, download the HW News app now from Google Play Store. The Supreme Court on Thursday ruled the rights available to married women under the Medical Termination of Pregnancy Act 1971 to abort a fetus will also be available to unmarried ones. The bench, presided by Justice DY Chandrachud, held while the 1971 Act was concerned with married women, the statement of objects and reasons to the 2021 amendment does not differentiate between the married and unmarried, and therefore all women entitled to safe and legal abortion in the country. The bench said that the artificial distinction between married and unmarried women cannot be sustained and that women must have the autonomy to have free exercise of these rights. The court said even unmarried women who become pregnant from consensual sexual relationships are entitled to terminate pregnancy up to 24 weeks. As per the MTP rules, only survivors of rape, minors, women whose marital status changed during pregnancy, mentally ill women or women with fetal malformation are allowed to terminate pregnancy up to 24 weeks. In cases of pregnancy due to consensual sexual relationship, termination of pregnancy is allowed only up to 20 weeks as per the Act and rules. The top court, however, held that such a distinction will be violative of right to equality under Article 14 of the Constitution. It said the law cannot create such artificial classification based on such narrow grounds of marital status. This is what the court said. The present case arose from a July order in which the Supreme Court had allowed an unmarried woman who became pregnant due to consensual sex to abort her 24-week-old fetus. The appellant, hailing from Manipur and currently residing in Delhi, had moved to the Delhi High Court after she came to know about her pregnancy. The High Court had refused relief to the woman, holding that an unmarried woman who is carrying a child out of a consensual sexual relationship cannot be permitted to terminate pregnancy older than 20 weeks. The High Court had said that Section 3(2)(b) of the Act is not applicable to the facts of this case since an unmarried woman and whose pregnancy arises out of a consensual relationship is clearly not covered in cases beyond 20 weeks, which is the outer limit laid down by the MTP Act, that is the Medical Termination of Pregnancy Act, and the MTP rules for termination of pregnancy arising from consensual sexual relationships. The complainant woman had then moved to the Supreme Court in appeal. The Supreme Court on July 21st overturned the decision of the Delhi High Court, which had declined to permit the abortion. The top court in its July order had also said that the law has to be given a broad interpretation and the intention of the parliament should be examined. In this regard, the court also noted that the Amendment Act of 2021 had inserted an explanation to the Section 3(2)(a) of the MTP Act, which uses the words woman or her partner instead of husband. The court read this along with the Clause C of the Rule 3(b), which allows termination of pregnancy in case of change in marital status. The clause has words widowhood and divorce in brackets. It therefore said that allowing the petitioner to suffer an unwanted pregnancy will go against the parliamentary intent and it cannot be denied to her only on the basis of her being unmarried, and being married or unmarried has no nexus to the object sought to be achieved. Pointing to the abortion rights for rape survivors, the court also said that married women may also form a part of class of survivors of sexual assault and rape, as it is quite possible that women may become pregnant on account of non-consensual act by the husband. In this context, the court said the meaning of rape must include the meaning of marital rape solely within the meaning of the MTP Act and rules. Now, what are the implications of this ruling? When the Supreme Court in the United States overturned Roe v. Wade, a law that protected the right to abortion for decades, there were several voices from India citing MTP Act and how India is ahead of the West when it comes to reproductive rights. That, in the recent times, brought into debate the MTP Act. The Act, however, over the years has come under criticism as it is far from perfect. The Act has been criticized for its systemic barriers, no complete autonomy to pregnant persons, not having rights-based approach, etc., etc. These systemic barriers made access to abortion for pregnant persons who don't fit into the criteria cited in the law difficult. For example, unmarried women. Earlier, unmarried women could terminate the pregnancy up to 3 months, that is till 12 weeks, under the MTP Act. The Medical Termination of Pregnancy Act of 1971 and its rules of 2003 prohibit unmarried women who are between 20 weeks to 24 weeks pregnant to abort with the help of registered medical practitioners. In case if a pregnant unmarried woman between 20 to 24 weeks wanted to terminate the pregnancy, she needed the permission from the court. Now, this point where the decision regarding pregnant woman's body by external agency who are not impacted by the pregnancy itself has even been criticized by the WHO. It has been observed in many cases when safe and legal abortion options are not available or access is restricted to avail it, pregnant persons tend to look for other abortion options that may not necessarily be legal and thus unsafe. Most unmarried women end up resorting to unsafe abortions in illegal clinics or at home. According to the latest National Family Health Survey 2019-21, 27% of the abortions were carried out by the woman herself at home in India. According to United Nations Populations Fund, State of the World Population Report 2022, around 8 women die each day in India due to unsafe abortions. It also found that between 2007 and 2011, 67% of the abortions were classified as unsafe. Unsafe abortion was one of the top 3 causes of maternal deaths. By denying the same rights under the MTP Act to unmarried women that married women had, the Act knowingly or unknowingly furthered a social stigma that still haunts unmarried women in India as well. With the latest ruling, the Supreme Court of India has taken a step forward to fix these loopholes in the abortion law. But there is still a long way to go. Do let us know what you think about this in the comment box below. For more news and updates, you can log on to www.hwnews.in.
Now be the first to know about the latest updates on our new news app. Go on your Android or iOS, search for HW News Network. Download our app, choose the language you prefer to get updates in, and be up to date with the latest news.